National Report Court is back in session. Today, we're taking up this case. Oregon's Hillsboro Topgolf location now being sued for $15 million after a 9-year-old boy was allegedly struck with a golf club and left with a serious brain injury.
So the lawsuit states the child was behind the driving range's red safety line at the time. And taking up the case is Hunter Shkolnik. For the purposes of this segment only, he's a trial attorney, and Ken Belkin is a defense attorney. Again, for the purpose of the segment, Hunter will represent the family suing. Ken will represent Topgolf, so we appreciate that. Hunter, the lawsuit says the boy suffered numerous injuries, including a skull fracture, an orbital roof fracture, cerebral hemorrhage, and traumatic brain injury. They say he required emergency neurosurgery as a result. How strong of a case is there right now, Hunter, for the family?
To be clear, a young child struck by a golf club is going to cause serious injuries. What we're seeing here is no shock. You have a situation where they allow people to drink, play golf, and they put a red line to stop you from going within the swing range. That's inadequate. They know there are going to be people, not just children, but in particular, when you have children there, the red line means nothing, and he was on the outside of it. Why don't they have netting? There are reports of other golfers being hit by clubs, by balls, by people behind getting hit by clubs and balls. The red line means nothing. And this is a case that's going to see its day in court. And this young child, unfortunately, is suffering from just, is going to be suffering the rest of his life. And they could have done something to prevent it.
And that's really at the crux of the case here. Ken, we'll go to you. Topgolf has not offered a public comment yet on the suit, but again, for the purposes of this court that we're hosting here with National Report, what would you expect the defense to be?
Oh man, I got to go against the kid with the traumatic brain injury. That's a rough one, but I will say this: where were the kid's parents? This is a place where you go in to participate in sports. You're assuming the risk. People know there's a chance of getting injured in sports, maybe not to this extent, but the child was not observing the safety protocols in place, went into an area he was not authorized to be in. There were warnings that children should not be there. The parents should have been adequately supervising them. I think a lot of this falls on the parents and not Topgolf.
All right. Also, this, too, and I'll go back to Hunter on this after we just heard from Ken. In addition to the injuries, as we were discussing, the lawsuit also claims that the Hillsboro Topgolf location, quote, failed to address, prevent, or adequately warn customers of the injuries that can be suffered at the golf range. Employees were improperly trained, and employees failed to present golfers with liability waivers prior to the party, unquote. How does that play into the case? And then, you also think about Major League Baseball, right? And you think about the netting that went up and fans that were injured, years back. But how does that play into it, that argument?
Well, in a baseball stadium, they're doing it, and you're far away from where they're swinging the bats and they're hitting the balls. Here, you're literally walking within feet of the swinging clubs. It's very simple to make the golfing area restricted off from the people walking behind. A piece of netting is not expensive. It protects the other golfers. It protects the people nearby, children or adults. And by the way, children don't assume the risk. 9-year-old children do not assume the risk. And a child being there, or that are there, maybe their parents have issues, but that child should never have been hit by a golf club.
Ken, I wanted to ask, maybe I've been to Topgolf before. I had a great experience, no injuries, thank goodness. Was it maybe just this location? Would that play into the defense?
Yeah, I mean, I think the plaintiff is throwing the kitchen sink in here with this lawsuit. They're alleging all sorts of things that have yet to be seen if they can prove at trial. How does the plaintiff know at this stage about the employees' training? I mean, what materials does he possibly have to rely on? They're throwing every possible claim in there, and they should. There's a traumatic brain injury. They want to get justice for their client. But I do think a lot of the responsibility is on the parents. Where were they? What were they doing? Were the parents drunk during this? No matter how many safety precautions you have, if you've got to be far.
All right, we got to leave it right there. Again, a lot on the line, $15 million, and obviously, most importantly, the health of the child. Hunter Shkolnik, Ken Belkin, stay with us. We want to bring in Doug Burns here, former federal prosecutor, live in the studio to play judge and jury. So, obviously, a sensitive case here, but you've heard both sides and how this would play out potentially in court. Doug, how do you read this case?
Well, it's a tricky case, and it's a close call, and it was very well argued by the two lawyers. Hunter lays out an overall negligence scenario. It's an environment of negligence. They didn't use due care to protect people. But then Ken counters with the fact that the parents are subject to a waiver of liability, which ostensibly extends to their supervision of the child. And so they were essentially negligent. So the verdict and the ruling is in favor of my good colleague, Mr. Belkin.
All right, Ken.
Oh, my God.
Got the win on that one. Again, this is National Report Court, so
I wouldn't have ruled in my favor.
so we'll wait.
He's appealing you.
He's appealing his own case. You believe that?
All right. How about that? You never know what you're going to get here. But we will watch and see how it plays out in, of course, the real world. Gentlemen, thank you all for coming on today. Hunter, Ken, and Doug. With
My
that,
pleasure.
National Report Court
Thank you.
is adjourned.
Thanks,
Take
Judge
care,
Burns.
guys. All right.
You got it,
Thank you.
Ken.